Okay, everyone, let's get started. Our next panel is going to be a conversation about damages and the use of experts to prove damages and where we are. I'm sure we'll talk about Daubert a little bit. We'll talk about new Rule 702 and the future of patent damages, where that may lead us. Our moderator is Megan Carpenter, and I'll just kick it over to you, Megan. Thank you for being here. I really appreciate it, and I'll let you take it away.
Thank you so much, Gene, and thanks to everyone for participating today. Before we dive in, I'll give a quick kind of analogy to anchor our discussion. So let's take IPWatchdog's own Renee Quinn. She holds a design patent, as many of you know. You may have seen it as you walked into the office today, for kind of a rope throw dog toy. There's a ball on a rope. It's simple, it's elegant, it's clever, and there's a design patent. Imagine someone is dumb enough to copy this dog toy, given the breadth of patent lawyers associated with IPWatchdog. So Renee is very well represented, and a lawyer needs to call an expert economist to testify as to how much money she's owed. So an economist walks to the witness stand, and the judge has to decide then, is this person's method scientifically sound in some way? Now, before 2023, courts often punted on this issue and let juries decide. But there was an amendment to 702 in 2023 that says, no, judge, you are the watchdog. I was waiting. I crafted all of that to make a bad pun. And so it raises this obvious question now. How do we calculate damages on the rope toy? Do we think about, do we think about the value of the rope from the ball? What if everybody's toy has a ball? What if the dog really likes the ball or the rope? And so that problem is what we're going to talk about today over the next hour. And it turns out it's a lot more nuanced and complex than it might appear at first glance. So we're going to anchor ourselves in kind of some of these changes with 702 today, and I'm going to introduce briefly our panelists, our panel of experts today, from whom I have already learned so much about the topic. I'll start with Jon Putnam. And he founded Competition Dynamics as really a platform for economic research and expert testimony. He is a 3-time Yale grad, a BA, an MA, and a PhD, and really was a pioneer in thinking about the valuation of patent rights with a book that a thesis, and then a book that he published in 2008. He has focused on IP rights, on innovation, thinking about a global perspective as well, with over 100 consultations and more than 40 times testifying across FTC, ITC, et cetera, and some of the biggest large-scale patent litigation that we see. He also is an academic and has taught at the University of Toronto, BU, Columbia Law School, etc. We also have with us Mark Nelson and Glenn Forbis. Glenn Forbis is with Harness IP, and he has been practicing for 31 years. And Glenn is a recent addition to our panel. So I'm going to let Glenn introduce himself in a more in-depth way, so I make sure that I do him justice.
Sure, no problem. So Glenn Forbis, I'm a partner and the practice group leader of the litigation group at Harness IP. I've been practicing 31 years. I'm 3 degrees from the University of Michigan, so I've spent my whole life there. So I have an MBA and a JD and a double E from Michigan. I've litigated my whole career, primarily doing that, and any type of technology. Had 10 jury trials, something like 25 Federal Circuit appeals, and over 300 cases in district courts. So yeah, I'm happy to be here, and thanks, Gene, for having me.
Thanks. And the reason he's a late addition is because of an email issue. We were crossing, and Glenn has been on our stage before and invited all the time. We really appreciate you being here, and I apologize for not having the communication the way that it should have been, but thank you so much for being here.
Thank you.
It also fits very well because Glenn has exactly 31 years of experience in litigation, and so does Mark Nelson. So the theme of the lawyers on this panel is who has 31 years of litigation experience. Mark is at Barnes & Thornburg, and he's litigated over 100 patent cases, including more than 50 as lead counsel, across the spectrum, sort of jury, bench, district court, ITC, IPRs, Fed Circuit appeals, and different types of technologies from semiconductors to med tech as well. And I think both Glenn and Mark focus primarily on patent litigation, but also have done a fair amount of copyright, trade secret, technology related. And one of the things that I think is a hallmark of both of their experience in private practice is that they have kind of both sides they've been on both sides of the coin. So what I will do now, I want to talk a little bit about the structure of our conversation today, and then we'll dive right in. So when it comes to expert witnesses, testimony, 702, the changes, we're going to talk about kind of what actually has changed. And then we want to talk about who's a winner and who's a loser in some of these consequences. Third, I want to talk about admissibility and weight, and the tightrope there that we see in application. Fourth, we're going to talk about discovery a little bit, and then we're going to predict the future. So first, let's talk about what has actually changed. And I want to make sure that you all feel comfortable. The panel said that they'd love to have questions throughout. So if we can save some time at the end for questions, but if you have something that comes up during our discussion, don't hesitate to make this kind of an active conversation with all of us. So what actually changed? Mark, I'm going to start with a question that you proposed during our planning call. And many courts say that the 2023 amendments didn't actually change anything. It really just clarified the law. Do you find that this is, in your opinion, is this a true clarification, or is it in some way more significant than that?
Well, thank you. I guess before I start, I just want to say that the opinions expressed are my own. They're not of my firm or of my clients. So with that disclaimer, I think if you look at the actual amendment to the rule, there were two changes. One was it inserted that the proponent of the expert report has to prove by preponderance of the evidence that it should be let in per the court's gatekeeping function. And then the second part that was amended was that it basically reiterated the expert can't go beyond sort of what the methodology that presumably he followed that would make it admissible. He can't extrapolate beyond that to a conclusion that otherwise would not be supported. And the actual language that was changed is very little. If you read the comments to the rule, the intent was to stress to the district courts that they really need to focus on their gatekeeping function. Depending on what circuit you were in and what court you were in, some of the courts almost operated like under a presumption that, well, the report's admissible unless there's really something crazy wrong with it. Or some other courts were really tight on the gatekeeping function. And so the first portion of it, I think, the intent was to emphasize that this is the proponent's burden to prove that this report is admissible for all the purposes that the rule is there for. In reality, I don't know if it changed that much, if it actually changed that much, although the intent, I think, was to make changes. At least from what I've looked at in preparation for this conference, a lot of the circuits that were already sort of tighter with their gatekeeping function used this rule to sort of reinforce what they were already doing. And likewise, other courts that were maybe a little bit looser with their gatekeeping function looked at the rule, looked at the amendments, and said, well, it didn't change that much. There's other commentary that said it wasn't really intended to be a substantive change, and they sort of doubled down on what they were doing as well. So I think the jury is still out, so to say, as to whether 5 years from now that'll be the same thing. But at least at present, I'll summarize by saying, I think the intent was there to have the rule make somewhat of a change, but in practice, I don't think it's really changed that much. Everybody just doubled down on what they were already doing.
Glenn, does that reflect your experience as well?
It does. I think academically, the change in the rule is very significant, right? Because I think the second part of the amendment effectively gives the court, in a way it didn't before, an opportunity to kind of pressure test, I'll say ultimately the conclusion almost, right? Based upon is the application of the methodology to the particular set of facts in that case essentially reasonable. They don't use the word reasonable, but that's the way I think it could be read effectively. Now, I think that's an academic change, because I agree with Mark that we're at such a level, it depends on the court you're in as to how they actually implement that. Where is the dividing line between, the so-called old way of effectively, was there an issue just with the methodology, or the new way, which is there a problem with the application of the methodology to the particular facts, and is it supported? So I think that my experience is that it really is court dependent still, because you're at such a level of analysis that it's difficult to determine where that dividing line is. Now, what I will say is emboldened a lot more, I think, Daubert motions than what were there before. Like when we look at things before, we may not file a Daubert motion because we're like, it's going to be an issue of fact, it's going to go to the jury. It's not a clear problem with the methodology. But now I think you can look at areas where maybe the application of the methodology doesn't fit the facts as well as it could, and maybe you've got a basis for a Daubert motion. So I think there's more Daubert motion fighting going on, and certainly from my experience, that's true.
Mm-hmm. Jon, as an economist who actually has to produce these reports, has this substantively changed the way that you do your work, or does it feel more like a fine-tuning?
Well, I think that the answer is, in the last 15 years, we've gone from a Daubert motion, just the filing of a Daubert motion being a black mark on your career, like, what did they do, what did I do wrong, to now you just have to expect it, like it's like a Markman hearing. You're going to get Dauberted full stop in a big case. It's going to happen. So since you know that's going to happen, you have to anticipate that in advance. So even sometimes if you're working for a plaintiff, even before the case is filed, you have to have, as part of pitching the case, you've got to explain how you're going to survive the Daubert motion. So in that sense, nothing has really changed. I think what's changed is it's emboldened defendants, because they now have helpful language which reinforces, they're threatening really the judge rather than me, and saying, you judge have to take a look at this. You can't just punt it to the jury, because if you do, you'll get reversed for failing to be a good gatekeeper. And so you see Daubert motions couched in language that is implicitly threatening the court, as opposed to threatening in addition to threatening the expert. And I think that's, and then taking that apart and saying, is it reliable methodology? Is it reliably applied to the facts? Do you have sufficient facts? Breaking it down and sort of in the way that Rule 702 does, and trying to identify weaknesses in each one of these elements, and trying to explain to the judge why you failed to meet one of the three elements. So I think it's emboldened defendants. That's why it hasn't changed my work that much.
Yeah, and picking up on what you said, Jon, when I first started doing this and was interviewing experts in the damages context, you would always ask, have you been Dauberted, has been successful, et cetera. And a lot of times the answer was no, and if it was yes, it was, oh my goodness, I'm not sure we can move forward with this person. Now, it's like, you haven't been Dauberted, you must have never testified in anything big.
Let's dig in a little bit now to kind of winners and losers. Piggybacking on what you're saying, Jon, I feel like I have to ask you about something it was really striking during our prep call when we were having the conversation. Most people would assume, or I would assume in this scenario, that the tighter the expert rules, that it's going to hurt the plaintiff, because they're the ones that have to prove the damages. But you've argued that the picture is more complicated than that, and I was wondering if you could explain that and talk more about that here today.
Yeah. So I went to graduate school because I actually liked trying to figure out the truth. And I think if you view damages as being a truth-seeking exercise, which is how I view the increased stringency of Rule 702, the court saying you're actually trying to figure out the truth, then that plays to my strength, because that's how I was trained. So increasing the stringency of Rule 702 is harder for plaintiff experts in the first instance if that's not how they're trained. So you see this, for example, in the Echo Factor versus Google case. From my perspective, that case was badly litigated in the following sense. The damages expert was relying on a royalty rate that was put in a license but otherwise unjustified. And when asked the basis for that royalty rate, he cited the CEO of the company, who was actually unfamiliar with how the rate was calculated. And it was a lump sum, the license gave a lump sum payment without any reference to the number of units that were being licensed, so you couldn't figure out a rate. And so there was a chain of reasoning that allowed you to cite witness testimony, but there was not a chain of logic that generated the number that the expert was relying on. And so the Federal Circuit en banc threw that out and said there wasn't sufficient facts to base the damages theory on. And I think that's, if your goal is truth-seeking, then you would applaud that decision and say there probably wasn't sufficient facts. The problem is that when you get to cases that are methodologically more difficult, where there clearly are sufficient facts, it becomes more difficult for defendants because they have to argue that on scientific grounds, not just legal argument, but they've got to present scientific evidence that the plaintiff's method is inadequate. And if the plaintiff has done their job, they should have had this vetted before they filed the case, whereas the defendant actually has a very short window of time in which, and usually when they've already retained an expert, to develop a counter theory and explain why the method is scientifically deficient. And that turns out to be hard to do, and it's especially hard to do because if you submit an expert declaration as a defendant, then you've got one expert saying that the method is scientifically valid and another one saying it's not scientifically valid. And this is a classic case where courts are like to say it's a battle of the experts. And if it's a battle of the experts, then it's going to go to the jury. And if your goal is to preclude the plaintiff's expert from testifying, then you have lost if you only fought the plaintiff's expert to a draw. So for defendants, it's actually increasing the stringency of the testimony works long-term to their disadvantage if the plaintiffs are taking Rule 702 amendments seriously and doing their job to present scientifically valid testimony in the first instance.
Yeah, but on that point, if the plaintiff's expert does their job, right, then you have two apparently sufficiently supported competing theories, and that's the definition of something to go to the jury. True?
Well, no, that's my point, is that if your goal was to get the expert thrown out, if your goal as a defendant was to get the plaintiff's expert thrown out,
sure,
then you will have failed in that goal.
Sure.
And so it actually makes it harder for you if you are, whereas before, you could often use legal argument to get a plaintiff's expert thrown out. But the ironic, by raising the standard and by making this a truth-seeking exercise and emphasizing to courts that you are trying to weigh the validity of scientific testimony both for the plaintiff and for the defendant can't merely make legal arguments anymore. they have to have scientifically supported arguments. That turns out to be harder for defendants, and it makes it harder to actually establish that the plaintiff's testimony is scientifically deficient, because it becomes a battle of disagreement between scientists.
25% rule for years was scientifically adequate. In one flash of the pen in the unilock decision, it was gone. People have used Nash bargaining, right? Just within the past 10 days, that was sort of scientifically accepted, within the past 10 days, or as a matter of law, rejected sort of Nash bargaining because it was another, quote, rule of thumb. So I don't know, maybe you could comment on, so what is something that's sort of scientifically adequate when the Federal Circuit at times is mercurial, then customs get into place and then they go out, they kind of go out of favor.
Well, I'll give you my 30-second version. One of the ironies is that the 25% rule was developed based on a sample of Swiss chemical licenses from the 1950s and 60s, and it had no scientific basis. The Nash bargaining solution was part of the reason why John Nash won the Nobel Prize. So they are at complete opposite ends of the scientific spectrum, and the idea that they would be conflated by the Federal Circuit as being both rules of thumb is scientifically ridiculous. Although I agree with you, that's.
They tell that to the judge.
Well, 100% right. So all I'm saying is that as a person who strongly believes you should be relying on science, is I cite the science in my expert reports, including the Nash bargaining solution when it's appropriate to use that, and why it is that you can actually do that, why you can apply it, why it's not just a rule of thumb, but there's actual data and facts of the case that are employed in doing it properly. So you can't just exclude it offhand. So my point simply is that defendants have a lot of weapons, and I agree that you can, they've succeeded in throwing out damages experts, but it's getting harder if they're not, the plaintiff's experts are not relying on rules of thumb and junk science and that sort of thing, but actually going to the economic literature on, for example, the distribution of patent values, and presenting a theory that is not only difficult for the defendant to refute, but the defendant has hired an expert who's unfamiliar with that literature and so is not in a position to offer a scientific rebuttal.
Yeah, I see this as sort of an evolution going back to the 25% rule. From a plaintiff's side, damages experts, the 25% rule was often applied just very lazily. It was just, okay, it's 25%, no other basis, good enough, and it would get through. But beginning with patent reform back in the 2000s, the Federal Circuit has taken many, many steps, including abolishing the 25% rule and lots of other steps, smallest saleable unit, to tighten the gatekeeping function on damages. And this now 702 amendment, as it's being used, I think, in the patent context and damages context, is just a further evolution of that. And again, requiring that the plaintiff's expert do what they should have been doing to begin with, and that's, as John said, providing reports with a scientific basis. I think on the defense side, it creates a little bit of a catch-22 in that as a defendant, I represent both, and as a defendant, you should be planning your damages case once you get sued. You shouldn't be waiting till you see the plaintiff's case. But as John said, if you buy into sort of a competing rationale that rebuts plaintiff's expert but uses essentially the same methodology, well, then you've just undercut your Daubert motion, because you're basically saying, well, the methodology is correct, we just come out to a different outcome. Well, that's going to go to the jury, in which case, if you're a defendant trying to kick the other side's expert out of the case, you've lost, and that expert's going to get in. And so as a defendant, I think you need to take the rule seriously too, is if you're going to offer a counter damage proposal, it can't just be, well, plaintiff is wrong for X, Y, or Z reasons. You have to have your own science and your own number and your own rationale supporting that number. I'll stop there.
Can I jump in for a minute? Because this is a real pet peeve of mine, the 25% rule. Because I'm not going to say that there wasn't some laziness with its application, because I think that there probably was, right? And one of my friends, who's a former judge, is the one who wrote the decision that erased the 25% rule, and I disagree. That's probably the only decision he's ever written that I disagree with. And the reason is because it seemed to me that what we did is we said it can't be 25%. It's artificial. It can't start there. So what we're going to do is we're going to start at 0. Which is just as absurd as starting at 25%, because it could be, actually it's more absurd, because it could be 25%. It can't be 0, right? It has to be worth something. So it seems to me that what we've done in a large respect, and I'm sorry, this is like fingers on the chalkboard for me, because I feel like all throughout patent law so much, we rearrange chairs on the Titanic and think that we've accomplished something. It's like, no, you just started with different uncertainty from a different point of view. And if what we wanted to do is say, what I think we're trying to get at now with the evidence is prove it. Then start wherever you want. But I would pick a number higher than 0, because if there's been infringement, then there has been no arm's length negotiating, and it should be worth something to the patent owner. And I'll get off my high horse, but this is great panel so far, so continue, please.
Are you ready to talk about admissibility and weight? Do that. All right, Mark, you put it really well in our discussion. And so I'll throw out a question about, wondering when does a challenge to an expert's analysis kind of cross over from being a weight question for a jury to a reliability problem that the judge has to decide? And then in practice, how do you make that call?
Yeah, I mean, it's a tough call. I mean, the reality is it crosses over when the judge says so, on either granting or denying your Daubert motion. So I want to pull out something here real quick. I took a look at some other non-patent decisions, and this happens to be a mass tort one that I just wanted to quote. So this is a mass tort case from the Sixth Circuit. Won't name the name of the case, but the expert got excluded. And the Sixth Circuit is a circuit that really has always been tight on the gatekeeping function of the court. And so the expert's excluded, and here's the rationale and sort of a thumbnail of what the judge said. Expert relied on only one study and excluded 4 other studies that contradicted the study relied upon. Expert relied on animal studies but had no explicit experience interpreting animal studies and did not include linkage between the animal studies and what he was trying to do. The issue in question was trying to find a link between the use of a diabetes drug and potential heart failure. And then the third one was cherry-picked some data, relied on, and ignored other data. Well, depending on which side of the docket you were on, that sounds pretty darn factual to me in some contexts. Yeah. And in other contexts, it doesn't. And so it's a really hard decision. And like echo factor is another one, for example. Judge Stark's dissent, or concurrence in part, dissent in part, looked at echo factor, and there the expert took the lump sum royalties that the parties agreed to pay and basically extrapolated based on sales. Well, this equates to a per unit royalty, and then from that, the mistake in my view that he made was he said, and the parties agreed to that per unit royalty. And there was some language in the contracts that says the defendant licensees said, no, we don't agree, it's a per unit royalty. But the math was right. There's a line in the contract that said they didn't agree that's what it was. And the majority of the echo factor court jumped on that and said, well, wait a minute here. We have a factual basis for this report that's just wrong. It's wrong on its face based on the contract language, despite the fact that the contract language and that whole issue was never even briefed. It wasn't even part of any of it. And the court went off that direction and said, well, too bad, that's a factual issue, it was wrong, doesn't go to credibility, doesn't go to weight, we're going to reverse it. Judge Stark pointed out in his dissent, well, boy, that's really dangerous of opening a door, and I'm paraphrasing, but this holding should be really narrow to this set of facts where the expert explicit relied on a fact that was not undisputedly wrong. So to try to answer your question is, again, I'll go back to where I started. It really depends on how the judge rules on your Daubert motion. If I'm a defendant, I'm certainly going to take, my shot at trying to disqualify another side's expert if I think I can get, even a fairly good colorable argument that the expert's opinion is exceeding what the facts would support. And likewise, if I'm a plaintiff, I'm gonna take the other direction, and I'm gonna back it with as much science as I can back it, and try to backstop that science with some more science so that I can point to, my methodology is sound, it's been accepted in other cases, and so therefore I'm good.
Yeah, I agree generally. I think that the echo factor case was decided on a set of essentially egregious facts, if you will, right? Because the conclusion that the damage expert came to was absolutely inconsistent with the explicit words, right, in the license agreement. So consequently, it was a relatively easy case to say, we really disagree with what the expert concluded on a factual basis. But it did open up the door, and that's why I think that the results of that decision in combination with the change in 702 is going to result in a lot of case-by-case, jurisdiction-dependent results. And I think the dividing line between, one thing that is clear about the dividing line between weight and admissibility versus exclusion is if, just like in the echo factor case, if you have a conclusion in your expert report that is directly contradictory to a documentary piece of evidence, right, that can't be disputed, then you've got a problem. I think the question then becomes, well, what if it's contradictory to other evidence that's not necessarily so clear? That, in my view, should go to the weight as opposed to admissibility, but you never know what the district courts are going to do with it because it's so close to the line. And I think that's what creates the danger.
The only thing I would add to that is I think that the game, one of the things that was true in echo factor was, the assertion that there was an inadequate factual basis or it contradicted the contract language. And I feel like one of the things that I've seen as working, particularly for plaintiffs, but on both sides, is that the game is to increase the bar for what constitutes valid scientific testimony past the point where anybody could prove the fact in question. So, for example, I'll just take a simple illustration. Suppose apportionment comes up in almost every case. So suppose you had to apportion the value of a pair of shoes, okay, based on market evidence. And so you observe in the marketplace that a pair of shoes trades for $100. What would you say the value of the left shoe is? How does an economist establish that? Well, there's no market evidence. Left shoes are not traded by themselves. You have no facts. But if you've got a patent that concerns the left shoe but not the right shoe, that's the focus of the inquiry, and you've got to do some kind of apportionment. And if you say, well, it's reasonable to divide the value 50-50 between the left shoe and the right shoe, that might be reasonable, but that's just your opinion. Can you point to a scientific study that says that the value of shoes are divided 50-50? No, you can't. And so this is an absurd example, but in slightly more complicated situations, you're doing something that is reasonable, but there is no quote-unquote scientific basis for it, and so a good lawyer can say this opinion should be excluded because it's not consistent with the scientific literature. Sure. And the bar has become something that no one can meet because left shoes are never traded. You don't find the fair market value of a left shoe in the marketplace. So you've asked the expert to do something that is impossible. So from my perspective, the solution to this is to go back to what would be reasonable if parties were negotiating over it. Would it be reasonable for negotiators to assume that the value of the shoes is split 50-50? Because people solve these problems in the real world when there aren't scientific studies all the time. But that currently is not the law.
Yeah, no, I totally agree with that. I think that, what you've seen over the last 15 years is a raising of the bar to such a degree, and it couples with what Gene said about the 25% rule and why are we starting at 0%, right? It's so difficult for a plaintiff to apportion, and by the way, I practice on both sides, about 50-50 defense and plaintiff. So, I don't have a particular bent here. I'm not advocating a plaintiff's position, but it is so difficult, in my view, for a plaintiff to win on the apportionment side, to do to point to scientific studies or analyses sufficient to get over Daubert. And then you're starting at 0. You don't have a place to start, but yet the statute says you get at least a reasonable royalty. How do you reconcile that, right? There's cases that I've run into where the ability to prove through an expert what, at that level that you need to, damages is almost impossible. But yet you have a statute that says you should get at least a reasonable royalty. So how do you reconcile those two things?
No, I'll reiterate that, and to give, I think John's example was a great teaching example, but let's say you're suing on, a computer or a cell phone, and, something within one of the chips gives you, a little bit of a speed advantage. It's some little nuance to a circuit that you need to figure out, okay, what is the value of that to the overall product, or the smallest saleable unit if you're using the chip as an example. Well, it's probably likely that the defendant doesn't keep that information, how one little nuance change to some aspect of a chip basically increases the sales of the computer or the sales of the chip. And so as a plaintiff, it's your burden to prove damages. And again, I'm probably 50-50, 60-40 defendant plaintiff, and so I don't have an axe to grind either way. But Rule 702 really becomes, and particularly if it's continuing to be tightened, it's a real challenge to figure out an economically sound method supported by actual facts that will give you a value for that, and to get it through Daubert. And the topic we'll get to here in a second, you're also maybe not going to be able to get the discovery for that, because if you're seeking stuff from defendants, they're going to say you're on a fishing expedition and not want to produce a whole lot of things that you might find valuable for that analysis. Go ahead, there's a question.
Have any of you done apportionment surveys?
Yes.
Yes.
Damage experts aren't expensive enough, but
Yeah, then there's a whole body
That's a
of law
feature.
as to what all can be wrong with your survey. And you have another expert that you've got to get through Daubert if you're on the plaintiff side.
For sure.
Do you feel, along those lines, to build on your great question, are you seeing costs go up post amendments, or do you think costs are going down or about staying the same?
That's one of the biggest challenges that I have, is explaining the costs of the damages case. And I'm a big advocate of engaging your expert before the case, right at the beginning of the case if you're a defendant, all the way through discovery, because I think there's no better value you can get on the damages side than to have them engaged, guiding along the way and developing that case along the way with the liability, because I think the damages case is more complex than the liability side. But explaining that cost to the client has been a major hurdle.
Yeah, and I think that the experts needed in certain cases for that analysis have multiplied as well, because a lot of times you used to have it that the economist expert could deal with the damages stuff, and a lot of times they still can, but sometimes you need a scientific engineer to give you a quantitative value of the little nuance in your chip, or the economic value, scientific value that, well, this makes your video conference X% clearer, and somehow that then translates into this % more market share than you otherwise would have had, which is really hard sometimes for the economist to do. Sometimes there might be documents that lets that occur. And one of the cases that up until 6 months ago was seeming to be pretty decently sound was you used to be able to count features. And there's an old FinGen case, FinGen versus Blue Coat, that you could find a marketing document, and if it had 25 features, and you could have somebody say, well, 12 of these relate to this particular patented technology, so I'm going to count those 12, and then I'm going to weight them, and then I'm going to apportion. Well, recently, FinGen versus, I think it's Sonicare came out, and well, there they had main categories, but they had subcategories, and the expert didn't account for the value of the subcategories, so expert report gets tossed. So it's a moving target, and it's a hard target, and I think I call them bridge reports, which are I call them the name that I give the reports that is the science report that takes the value of the invention, quantifies it such that then the economist can rely on it for the numbers game. And so now with 702, you also have to have, in many cases, not all of them, but many, a report that withstands 702 scrutiny in that context to even get to your damages economics, which further increases the cost.
I think we're kind of touching on the discovery issues now, and Glenn, you mentioned your approach is to involve experts early. Are you finding that under 702 now that engaging experts from the discovery space is becoming standard practice, or are you still seeing people kind of parachute in at the last minute?
I don't really see a difference, in my practice. I don't do anything differently because I always wanted to get a damage expert involved early. I also usually dedicate at least, kind of a mid-level partner person at least to be the specialist on the damages case, just specialize on the damage side by, 100% because it's so complicated, with my oversight and my involvement as well. But you need somebody that just focuses on that, in my opinion, and you need to have your damages expert involved early. People do it differently. I see people not getting their damage expert involved early. I see them not focused on the damage case until middle of the case or later on, and I think that's a big mistake. It's too complicated, it takes too long to develop, to let it go. Mm-hmm. And the discovery is important. That's the other aspect, right? Which is, I think you need to do discovery on damages in waves because you learn stuff along the way of the case, and it's a big challenge because the defendants are fighting that, particularly that damage portion of the discovery tooth and nail early on. And so you have to really go to the mat on getting that early discovery on damages. And so I think that's important as well because otherwise you're going to find yourself the last 3 months of discovery trying to pick up your damages discovery, and it's just not enough time.
Mark, does that mirror your experience as well, or do you have a different perspective?
No, I mean, that mirrors mine as well. Again, I think regardless of whether you're representing the patent holder or the defendant, it really behooves you, and I've always tried to get the damages experts involved early because, I mean, if you're a plaintiff and you're trying to prove damages, there's a lot of different ways you can do it. I mean, the good part is the Federal Circuit is very open to different methodologies of proof as long as they're scientifically sound. And so by getting your expert involved early and helping to shape the discovery, I think you get the best thinking from the expert to help craft the damages case or multiple theories that give you the best chance of success. And on the flip side, from a defendant's perspective, I mean, it's always, I mean, most defendants, we don't infringe, we shouldn't talk about damages, we don't want to spend money on damages. Well, that's, for a big case, that's the naive viewpoint, and most of the big companies don't feel that way. But you don't want to be in a situation where plaintiff has a damages expert, $100 million, your damages expert says zero, both of them go through, the jury's given no choice between 100 million and zero, and if they happen to like the plaintiff, they're going to pick the 100 million, as opposed to, an analysis and a number that's somewhere rational from a defendant's perspective, but not zero.
John, I think that now that the importance of bringing you in early has been teed up, do you want to talk a little bit?
Firmly established. Not only a best practice, it's practically malpractice not to do that. So.
Do you want to talk a little bit about how that changes the, by bringing in an expert early, sort of changes the way that discovery is approached from day
Right.
one?
Well, so I mean, apart from helping Jon Putnam's kids go to college, since this is a panel on Rule 702, I think it's important to understand.
I'm glad you changed your name to Megan Carpenter, because now my kids can also go to college based on your...
We should probably explain that, because when we play this back, that may not be it. John introduced himself during the sound check as Megan Carpenter.
I'm not under oath.
Right, you're not under oath, right? So this is for those people who are watching outside the room at a later date. John is not, in fact, Megan Carpenter.
For purposes of my kids' college tuition, he may be. But John, could you tell us a little bit about your perspective on
in the
that?
Rule 702 context?
Yes.
It's actually interesting for me as an economist, because when I think about, well, how are you going to prove the value of a feature, for example? And if you think about this from first principles, apportionment and incremental profit these are really causation questions. And so how do you measure these things, and how do you establish causation? So one of the ways you do that is kind of with a statistical version of the experiments that we all did in third grade. So if you want to know what causes a plant to grow, you take two plants, and you put one of them in the closet, and you put one of them on the windowsill, and you see what happens to them. The one in the closet dies, and your teacher said, what was the difference? And you learn that light causes plant growth. And that's really, philosophically, how you prove the value of an input into a device. What's the value of light, or what's the value of some particular feature? So the way you do that statistically is you collect information not only about the product that is accused of using the device, but about products that don't use, or the patent, that don't use the patent. So you want, ideally, you want sales evidence not only from the date of infringement on when the feature was added, but sales prior to the date of infringement before the feature was added. And you also want sales of related products that don't contain the feature. So if you have before and after and without, then you have an experimental design that economists call difference in differences. And then you can measure the effect of the feature, controlling for other things that are going on in the environment simultaneously or before and after. The problem with that from a discovery perspective is that if you ask the judge to give you access to sales of products other than the accused product, you'll often be denied. And so, and the defendants naturally argue that this is a fishing expedition, these other products are not related and that sort of thing, because they don't see how you're going to use the experiment, and maybe you can do it and maybe you can't. But so the point of it is that if you're going to hold an expert to a scientific standard, then you have to give them the data in order so that they can perform the science that you're ultimately requiring of them. If you deny them the data, then you can't say, well, you can't then argue the expert's method was scientifically deficient if the expert couldn't conduct the experiment that he would have conducted otherwise. So I think you're setting up a conflict going forward where it's both a strategic conflict and a legal conflict. Do you grant the expert access to the additional data and then argue that their method is deficient, or do you try to deny them access to the additional data, but then lose the ability to argue later on that the expert's method was deficient because you denied them the ability to do the scientifically valid thing? That's going to be an interesting dilemma that defendants will face, I think, down the road.
Yeah, and that problem is real, because we've run into that recently as well, which is, on the plaintiff side, seeking sales information for non-accused products, but parallel, to the accused products, and trying to get the judge to understand against the argument that, hey, it's a fishing expedition, they're going after products that aren't accused, they don't have anything to do with this case, and trying to explain why those apparently tangential products are relevant to a damages calculation for the accused products is a truly uphill battle. Because most of the time it's a magistrate judge you're dealing with, and not anything against magistrate judges, but they're not. You typically don't get the time of day on some of those complicated arguments, in my experience, in a discovery motion. They don't want to be in a discovery motion anyways. But on something like that on its face looks like it's tangential to what you should be getting in discovery, that's a tough battle.
Yeah, 100% agree. And also, at least if you've sought all of that information and been denied, when the expert gets Dauberted, you can point to the court. Look, I mean, we tried this, we tried this, we tried this, we tried this. You denied it all. This is what we had left. This is the science behind what we had left. You know, it's as good as it can be given the rulings that you made. It may get you somewhere, may not, but at least you have those arguments.
In our remaining 10 minutes, I want to do two things, and please do continue to feel free to ask questions as we go along. But I want to talk a little bit about the future, and then we'll focus on some practical advice and takeaways. Mark, you had mentioned that the possibility of Supreme Court intervention in given sort of continued divergence in approaches. Do you think this is this inevitable? Is it likely? What does it look like? And I'd love kind of both your and Glenn's perspectives on that.
Yes, I would say it's not inevitable, certainly. Is it likely? Possibly, depending on how the circuits continue to treat this. And I don't know if it'll come up in a Supreme Court in the patent context, but it very well could in other contexts dealing with Rule 702, because that's applicable in all cases where all federal cases where there are experts involved. And so certain venues and certain circuits are, and again, I'm generalizing, but at least at the circuit level, they're taking their gatekeeping function real seriously, and it's very, those experts are really being put through the filter before their opinions are let in. And other circuits are much more lax is probably the wrong word, but not as stringent, I'll just say. And if those bodies of law continue to develop and continue to diverge, I could certainly see that it's possible that the Supreme Court would step in and try to set a more uniform sort of definition of what meets scientific rigor and how far you can extrapolate from that before you have extrapolated too far and your method is no longer supported by the facts. But again, this is such a fact-specific inquiry, case by case, that it's unclear but possible. So I'll leave it.
Mm-hmm. Glenn, what about you?
Yeah, I don't see that this. I don't see this as going to the Supreme Court. I think the rule is fairly clear. It's just a different application of it, and I think that what we're seeing is effectively a case-by-case assessment on kind of where that line is between admissibility and weight. And I think that those are the types of things that, in my view of the Supreme Court and the Federal Circuit, they've moved towards that direction as opposed to the bright line rules. And so consequently, I just don't see that. I personally don't see it going to the Supreme Court to reconcile kind of the nuanced application of the rule.
Well, we all know how much the Supreme Court likes patent cases, so I think if you were betting on that one, you'd have to bet against. I actually think that Daubert was a Supreme Court case, so you could imagine this happening. Mm. The thing that makes patent cases different, and I don't think it'll go to the Supreme Court, but it's important to note that it's not just science. In the following sense, if you think that a hypothetical negotiation is the right way to think about measuring damages, and I think it's often not the right way, but it's useful to think of people bargaining on the eve of infringement. The question is, how would they think about this problem? And based on what information that they had at the time, what sort of solution would they reach? That's not science. That's kind of forming expectations. And there's right and wrong ways to do that, but reasonable minds can differ, which is why you guys all negotiate complicated license agreements. The ability to of an expert to say, here's how expectations would have been formed based on the information that is available to me now and that was available to those parties on that date, That's an extremely difficult problem because it's not just science. It's basically an opinion about imperfect information. You can't always measure that. And you might wish you had more information, but the fact is you don't. And so are you going to exclude the expert? How do you think about that bargaining process when both sides don't have perfect information? That's not really, I don't think, a Supreme Court worthy case, but it's an extremely difficult case, and at some point the Federal Circuit's going to have to come to grips with it.
Okay, in our remaining 5 minutes, I love a good lightning round, and I love a practical takeaway. So if each of you had one piece of advice for the people either listening in this room or listening online, watching it later, one thing to perhaps do differently, what would you suggest that should be? And I'll throw it up to anyone who wants to go first.
I'll go first. Preparation, and focus on the damage case in parallel with the liability case from the very beginning with waves of discovery. I just see it way too often that people wait too long on the discovery side to think about getting what they need and thinking through the damages case. And if you do that, you don't have enough time.
I guess I'll add to that more preparation. When you're picking venue, if you're a plaintiff, use the tools that are out there to look at how the judges in that venue you might draw are going to rule on Daubert motions. That information's out there. If you're trying to decide between two competing venues that otherwise both are likely good venues, that could be an interesting data point. Completely agree on both, and this is from both plaintiff and defendant side. Focus on the damages case early. If you're a defendant, push plaintiff to get its damages case out there so that you know what it is, you know what you're shooting for. If you're a plaintiff, don't be wedded to one theory. Get your expert involved very early. Look at all kinds of different alternatives that you can use to prove damages. Start seeking documents so that when you're taking depositions, you're taking them after having already really thought through a lot of this stuff, so you're taking them to get admissions that you actually can use as opposed to just learning information. And I guess I'll stop there.
I once met the first chair partner in a case that I was testifying in on the way up to the witness stand. And I shook his hand. We were at a break. I shook his hand and he said, "Hi, nice to meet you. I'm really sorry I have to give you 20 minutes of my time because I'd rather would have spent it on invalidity." And so, needless to say, I rushed through the testimony and it didn't go well. And so I tell that story to say it's actually really important to integrate the damages theory early on thematically with the rest of the case. So if you're a defendant, you don't want to be perceived as simply in denial mode. You want to be somebody who's willing to pay the fair market value of the invention. That converts you from being a black hat to a white hat. But you just disagree on the value of the invention without giving up your non-infringement position or invalidity position. You're willing to pay it, you just don't think that the plaintiff has measured that value accurately. And that thematic involvement is something that occurs very early on in the case. So I also think that it's good to get a damages expert involved in early. The other piece of advice I would give as an economist is ask yourself whether you've got a counterfactual case or a measurement case. And what I mean by that is, are you able, given the data that you have, to measure the value of the invention? Or is the primary point of the damage expert's testimony to imagine the world in which there is no infringement? If you've got a measurement case, sometimes you can get by with an accountant, and sometimes you need an accountant because you're measuring things that are, from an accounting perspective, actually complicated, and you need a technical expert to help the accounting. If you've got a counterfactual case, which is really much more naturally the way the damages experts, the damages question is posed, what would have happened in the absence of infringement, then you should think seriously about hiring an economist, because that's the way economists think. They ask counterfactual questions about what would have happened, not actual questions about what did happen. And that's an important conceptual distinction that you should satisfy yourself with early on.
Well, thank you. That was perfect timing. And we are so fortunate. Let's give a big round of applause for our three experts today.